Hello everybody, my name is Yunfei Zhao and today I will be presenting Gregg versus Hay Adams Hotel. From a managemental point of view, I consider this case very instructive for future hospitality attendees. First, I will present the fact of this case. The plaintiff is Denise Gregg, a pastry chef in Hay Adams Hotel. On April 14, 1994, Gregg filed a formal complaint against his supervisor, Clark, for unwanted sexual harassment. The report filed 8 months after the alleged sexual harassment was occurred. Another female employee, Dade, made an independent complaint about Clark at the same time. After the complaints, assistant who handled the case notified the information to hotel human resource director. The human resource director notified the general manager of the hotel, requesting a formal investigation with the issue. On April 26, 1994, the general manager issued Clark an official writing warning. Any future misconduct will lead to termination of employment. There were no claims of any form of sexual harassment after April 14, 1994. However, Gregg, in this petition, alleged that on 3 different occasions, the supervisory employee of Hay Adams Hotel engaged in retaliatory conduct because of her complaint. Finally, Gregg filed a sexual harassment suit for violation of civil rights, Title VII, and seeking $2 million compensation. There are 2 legal issues occurred in this case. Based on the plaintiff's allegations against the defendant, the court identified 2 issues for the determination. The first one is, did the defendant's inaction to prevent sexual harassment creating a hostile work environment, thereby breaching Title VII? The second one is, did the 3 adverse actions against the plaintiff amount to retaliatory acts against her on amount of lodging a sexual harassment case against the defendant in violation of Title VII? Since the legal issue has been demonstrated, let's look at what actually happened during hearing. Defendants took several meaningful actions to address the plaintiff's sexual harassment claims, thereby negating Title VII liability. There is no evidence suggesting the defendant or her agents directly creating a hostile work environment contrary to Title VII. In fact, the hotel's new human resource director, Louise, toured the kitchen severely to monitor the working conditions and ensure that the environment was not hostile to the employees. Another fact is the retaliation claims. None of those claims have a direct cost associated with her filing a lawsuit. The warning was justified because the plaintiff acted in full awareness of her employees' work policies. The court determined that the hotel was acting in accordance with the workplace policy standards to correct the employees. The plaintiff could not provide legitimate ground that attribute the court's warning to her lawsuit. The court decision was no surprise. The court dismissed all plaintiff's claims and issued a motion of summary judgment in favor of defendant. From a personal perspective, I agree with court's ruling. When the company detected the potential harassment complaint, they took several necessary precautions to ensure the rights for their employees. Secondly, the alleged retaliation cases were not retaliation. All decisions were made under the code of conduct of the hotel. I think the court's ruling was impeccable. In the beginning, I said this case is instructive because it happens a lot in our industry. As a future hospitality professional, we need to determine the hostile work environment and provide necessary training for employees on preventing sexual harassment incidents. Also, as an employer point of view, we should know their liability on protecting employee and enforce any regulations and laws. Thank you so much for watching. Thank you for watching.